everyone. Welcome to Let's Talk. I am your host, Marie-Yves, Nadine Jean-Baptiste, the owner and CEO of the St. Eve Law Firm located here in Towson, Maryland. So, as you know, I usually like to start these shows with just a little bit of an update as to what's been going on, any changes that we're making, and not too much is going on this week. We are announcing that we are closing next week, Friday, which I believe is April 15th, which also coincides with Good Friday. So for individuals that celebrate Good Friday, you can focus on that and you don't have to worry about calling your attorney because we will not be working. We will be somewhere resting, much needed rest, trust me. Last week, we talked about, actually, before I get into that, for anyone who is still calling us with family law inquiries, we still get quite a few. Please send us an email at info@steveelaw.com. We will go ahead and send you some referrals. We actually have a network of attorneys that we refer cases to. These are attorneys that I am personally familiar with, whether they've worked with me on a matter or whether, they've counseled me on something as a new attorney. I made it my thing to reach out to people who have a lot more experience than I do so that they can, kind of guide me and help me so that way I can help the client and also not get sued, right? So the next thing I wanted to talk to you about is last week's topic. As you are aware, hi Tanae. Last week's topic was our discussion on some of the proposed changes that the Senate and the House is looking at as far as, the notice procedures when a trustee is resigning or when he or she is ultimately closing the trust, distributing property, and or trust proceeds. So if in the event you want to review, I always forget to do this, but you can go to it's Legiscan, Legiscan. It's legiscan.com. You can go ahead and you can follow up on all of the bills and just ultimately where they're going and any decisions, any meetings that are coming up. So that way, your voice can be heard, right? Because our laws ultimately affect our state, and our state is made up, some wonderfully intricate humans. So if it impacts you, you should definitely have a voice as to whether or not, you agree, or just at the very least, just stay in the know. So today's topic is fees, right? Specifically, personal representative fees and attorney's fees. So when administering an estate, and I know a lot of you are not necessarily familiar with the estate process, but a personal representative and an attorney is entitled to fees. Now, there is a cap on those fees, and if you want to go above that cap, then you have to petition for extraordinary fees, right? And it really just depends on what you've done and just the amount of work that was absolutely necessary, ordinary and necessary to administer the estate. You can't just rack up fees and expect that you're going to get paid for it. One of the things that I always make sure to do when we're accepting an estate is I always explain to my client that my fees are literally governed by statute. So if the cap is $5,000, I can't ask for $15,000. I can't ask for 10 without actually having done all that work. One of the things that we do with closing the estates is we send over our invoices along with the final accounting or the modified administration report, letting the court know, hey, this is all the work that we've done. If the court is okay with the work that we've done, they will go ahead and approve my fees. If they're not, then, they'll call us in and say, hey, we need to talk. Here's a hearing date. Here's a time. Come on in and explain to us why your fees are what they are. Thankfully, I've never had that happen, but unfortunately, it is a risk that you take, when racking up fees. So more specifically, today, we're going to discuss Section 7 of the Estates and Trusts article. So section 7-601 and 7-604. This is outlined in the Senate Bill 468. We will have the link up for anyone who is interested. I'm going to go ahead and post it in the comments now. So that way, anyone who is interested in reading the bill, it is a short one. It's about 3 pages, so it's not going to put you to sleep. So you should be fine in reading it. It's pretty straightforward. It is not like our tax code. You can actually understand it. So anyway, the section is called Payment of Commissions and Attorney's Fees Without Court Approval. So when administering an estate, the Register of Wills, they have a really great website where you can get some of your forms on there. They like their things to look a certain way, so we always use the Register of Wills forms. We also have created some of our own that we use, but realistically, it's just easier to go on here and get whatever form it is that you need. So one of the things that they have, it's called a consent to the compensation of the attorney or the personal representative. I've added the link to the forms in the chat box. So for anyone who's interested and has a little bit of time on their hands today, they can go ahead and peruse that at their own time. But one of the things that you have to do is determine whether or not the PR is going to consent to your attorney's fees. And there is a consent form that is required. It's very straightforward. It is, thankfully nothing too crazy, but it takes the place of the petition for attorney's fees. When closing an estate, you do have to ask for your attorney's fees unless there's a consent form. It's 1 page, a few simple questions, some math, but all heirs and all creditors who have open claims, they must consent. I personally do not like to do that until all creditors' claims have been satisfied. We make it a point to negotiate with creditors. I am of the opinion that in the event, someone passes away, their debt should pass with them. But I also know that that is not the law, right? In some cases. So when a creditor files a claim and that claim is open and it is timely and it's valid, meaning it's within that 6-month period that is allowed for creditors. There are some exceptions, of course, but we won't deep dive into that. Then ultimately it has to be paid. So my firm and I, we work with these creditors. We try our best to lessen the debt so that way the estate could save a little bit of money. And once they do that, they file a notice of satisfaction, letting the court know that this is settled, everybody can move on. So in the event you don't have any of these open, then ultimately, you can file that consent and attorney's fees can be paid. The PR can get their commission and the estate can be closed and proceeds distributed. So some of the changes that are outlined, again, it's not that many, thankfully, but some of it is stylistic. There is a provision here added that says that if the consent is not filed at the time that the accounting or the modified administration report is filed, then ultimately whatever attorney's fees that the attorney is asking for can be paid, but up until that point. So any work that is done afterwards is not considered in that consent. What I take that to mean is we still have to prepare a separate petition for attorney's fees in order to obtain any additional fees that may have already, that may have accumulated. Me personally, that's more work. I don't like more work. I also don't want my clients to have more fees. So if we're going to do the consent, my personal practice, I cannot speak for any firm, but my personal practice is in the event we're filing a consent, I'm not billing for anything afterwards. So ultimately what that means is whether it's revisions, whether it's follow-up, it doesn't matter what it is, we're just not going to bill for it. So that way we save our clients, some money as far as the legal work and as far as, preparing any petitions or anything like that. So that's kind of the major change that is taking place to section 7-604. They've added a new section 4. Again, this is under section 7 of the Estates and Trust article. And that pretty much concludes, actually, no, there's one more thing to note. Just remember that as a personal representative or as an attorney of an estate, again, our fees are governed by statute, right? And the formula, most people don't know this formula, so I just kind of want to put it out there. Our formula is 9% of the first 20,000. So if you have an estate worth $100,000, you minus that 20,000, that's $1,800. That is the fee on the 20, and then 3.6% on anything over that. So 3.6% of 80,000. Okay, you put those together, that is your maximum statutory fee. So what that means is that if you want to go over that, ultimately you will have to petition the court, and you will have to ask the court for permission in order to get paid that amount. Okay, and as I stated earlier, the personal representative's fee is also subjected to the same. Personal representative and the special administrator is subjected to the same fee cap. Okay, so that's something to keep in mind. So that pretty much concludes the possible changes on Senate Bill 468. It is currently passing through right now. Thank you, Tanae. It is currently passing through right now, and it has been approved upon, I believe, the third read. So just continue to track the bill. I will continue to track the bill. It is my job. Tanae said I didn't know the percentage. Unfortunately, a lot of people don't. And they think that, it's just based off of the hours that you work. And it's easy to think that, but it's not. There's just but so much of a percentage that you can get. And there are different types of fee arrangements. You can actually have a contingency fee arrangement with the attorney. That is covered in the second section of 7-604. Section 602 covers the attorney's fees portion, and 603 covers litigation expenses. In the event an attorney takes place in litigation, I've done so, in removing personal representatives. We've done so in, litigating creditors' claims, things like that. Unfortunately, it does create litigation, and any fees that we incur as a result of it, even if it is over that statutory amount, we are able to get that back due to litigation, as long as we didn't cause the problem, and we're not creating even more fees for our client, right? So of course it's within reason. It's the law, so it's super fluid, lots of exceptions. Everything is not super black and white, especially when dealing, with the ENT article. So yeah, with that said, if you have any questions, give us a buzz, 443-707-8692. We are here 24/7 to answer questions. We aren't, me and my colleagues aren't, but the receptionists are available to answer your questions. Leave a message and we'll get back to you at the next business day. We are open this Friday until 1 p.m. Our firm closes every other Friday, and every other Friday we are closing at 1 p.m. We are ultimately tweaking that a little bit, and we will be closed every Friday going forward. I think we all, deserve a little bit of a break. So we'll keep you tuned in for that. Thank you everyone for watching. Thank you, Mom, for watching. She just had surgery, so she's chilling, well, not chilling, but she's in pain at the hospital, and she's always super duper supportive. So thanks, Mom, for tuning in. Thank you everyone for tuning in, and you all have a great day. Again, I am Marie-Yves, Nadine Jean-Baptiste. Tanae said nice 3-day weekends. Yes, I like those. Thank you everyone for tuning in, and have a wonderful day. Stay blessed. Bye.